Good afternoon. Good afternoon, everyone. Thank you so much for spending your Friday afternoon with us. We appreciate you being here. My name is Erica Bracy, and I manage Launch GSU, your student business incubator. This is the space on campus for all the Pantherpreneurs who either have existing businesses or are looking to start a business. Many of the names that have joined us today look very, very familiar, but I'd like to say welcome and thank you to all of you who are joining us for the first time. We have several events throughout the month and try to do our best to make sure that we minimize the technological challenges, but it happens. So we appreciate your patience and thank you all for bearing with us and coming over to the new link. So we are super, super excited about today. This is our very first presentation on trademarks. And from the response that we received, we found out that there is a lot of interest and excitement about learning more about trademarks. So we thank you for taking time out of your day to join us. And I'm super excited to introduce our presenter to you today, Attorney Dana Dickson. Attorney Dickson is an apparently Atlanta born and bred. She is a graduate of Emory Law. And of course, Georgia State, we love Emory. Emory doesn't have a rival football team, so we absolutely love Emory Law. Um, but she also holds a master's degree in art administration. Prior to founding her practice, Dana Dixon Law, she actually worked with the U.S. Patent and Trademark Office for several years and reviewed thousands of trademark applications. That is a lot of reading. I guess that is you absolutely must enjoy reading. But prior to her work at the USPTO, she also worked for a boutique civil litigation firm where she represented individuals and businesses of all sizes and all stages. She has also had the opportunity to work with a variety of nonprofits, including arts and cultural organizations such as music venues, opera companies, as well as an art gallery and a museum in the United States as well as across Europe. So she has a ton of actual practical experience in this area, which appears to be her passion. Attorney Dixon is a member of the International Trademark Association as well as the intellectual property sections of the ABA, the American Bar Association, and the Georgia Bar. The beautiful part is she says she is working her dream job. She has the opportunity to talk with innovative clients, business owners who are passionate about their projects, and she has the satisfaction of finding creative ways to solve their problems and help you get something that you really want. Ultimately, that's the true definition of an entrepreneur, solving problems creatively. And ironically, Attorney Dixon, as I mentioned, being an alum of Emory, she just happened to reach out to me. Her father is an alum of Georgia State. He's a Panther, and she decided she dug deep into her heart and in the spirit of giving back and paying it forward, decided to reach out to her father's alum, not just the alum of her alma mater. And so for that, we are incredibly grateful and would like to welcome Attorney Dixon with a big rounding Panther virtual round of applause. We thank you so much, Attorney Dixon, and hope that this will be the first of what could be a long relationship with you. So thank you so much. And without further ado, I'm going to turn it over to Attorney Dixon.
Thank you so much for having me, and thank you for that introduction. That was super nice. So my purpose here today is really just to explain to you what a trademark is and some of things you want to take into consideration if you ever want to protect one. So I'll give you a quick idea of where we are headed. We're going to start out by talking about what a trademark is and what it is not. And then we are going to talk about when you want to think about trademarks. So I'll give you three key considerations for kind of that timeline. And then we are going to move down into talking about searches, which are super important, and you will understand why in just a few minutes. And then our last topic is going to be distinctiveness. And this is really just how weak or strong a particular mark is. And then hopefully we will have some time here at the end for questions. So let's jump right in. What a trademark is and what it is not. Oh, it is requested that I speak up a little bit. Okay, I'm going to try to get closer to my instruments. Can you hear me better now? Hopefully. Okay.
Yes, that is better. Yes.
Okay, good. So a trademark is not a copyright. It is not a patent. But these three things get lumped together in a category called intellectual property or IP. So people get them confused all the time. IP is just a certain category of asset. It's a little bit different from owning a house or a car. But these three things protect different things. They last for different amounts of time, and some of them are much easier than others to get. I will tell you right off the bat, a copyright registration on average is much easier to get than a patent or trademark registration. The review process is more lenient, the rate of refusal is much lower, and it is also cheaper in terms of the filing fees to apply. Another key difference here is that copyright and patents last for a limited period of time. So there is a certain term of years that these will last, and then those rights expire. It goes back out into the public domain, and people can copy. Trademark is the only one of these three that can, in theory, last forever, or at least as long as there is American law. So you just have to keep on using your mark in the real world marketplace and file your maintenance and renewal documents with the USPTO after you get that registration. But in theory, it can go on and on and on, which is really powerful protection for a brand. All right, so I want to give just one slide to each of these to talk about what they protect, what they cover, because it is a little bit different for each one, and I want to make sure we are super clear in terms of what we are talking about. The trademark is a source identifier, and if you remember nothing else from this presentation, hopefully you will remember those two words, and it's super important. So what does that mean, source identifier? That is a shortcut that all of us take every single day as consumers to get more of the things that we already know we like. So a quick example here. One of my guilty pleasures in life is McDonald's French fries. And I know they are really bad for you, but I don't care if I have had a bad day and I'm driving around. I want my comfort food. I am going to look out for certain source identifiers that get me to those fries as quickly as possible. Okay. So I might look for the golden arches. I might look for the wording McDonald's. Either way, when I see one of those, I know I can turn in there. I'm going to get the fries I want. I do not have to go to 4 or 5 different restaurants and order the fries and see if I like them. I know how to get more of what I want because of those source identifiers. So when you think about trademarks, you want to think about slogans or logos or product names or names of service providers. There are other things that can act as trademarks, but those are the main ones. All right, now a copyright is something a little bit different. This is protection for original works of authorship. And here you want to think about things like books, paintings, movies, photographs, songs. And the copyright protects the substance of those works. So you are getting protection for the text of the book or the composition of the song. But notice that is something different from telling me where to go to get more of the books that I like or more of the songs that I like. That would be in the realm of a trademark. All right, and then a patent is something even a little bit different from that. Okay, it's protection for a new and useful process, machine, manufacture, composition of matter, or improvement to any of those things. Patents can get hyper technical. We're not going to go down that path today. We're going to keep it nice and simple. So just think about inventions, a new type of product, a new feature for an existing product. You might have this product that has been around for 30 years, but you have found a way to make it more user friendly or more efficient. That might be patentable, or a new way of doing something. But notice again, this is protection for, let's say, the design of that new product. It is not telling you where to go to get the new product. That would be the realm of trademarks. All right, now, this is the one and only flowchart slide, I promise, in this whole presentation. So hang in here with me for just a couple minutes and everything from here on is just downhill and easy. All right, so I just want to give you an idea of what the process looks like and why people bother to go through it, what they actually get at the end with a registration. So in the beginning, you have a mark, and if you are using that mark with goods, it's called a trademark. If you're using it with services, it's called a service mark. But for purposes of this presentation, I'm just going to say trademark, whether I'm talking about trademark or service mark. It makes life easier for everybody. Okay. So you have your mark, you want to protect it. You apply to the USPTO to register your mark. The USPTO is the US Patent and Trademark Office. It's a federal agency of the US government. And what happens after you file your application is that 3 or 4 months later, an attorney at the USPTO is going to review that application. They're going to look for dozens of potential problems with it. And they're also going to do a search of the Federal Register for similar marks. Now, when I say they do a search of the Federal Register, this is they look at a big database of all of the registrations that have been granted in the past, and they are going to see, well, is your mark too similar to any of those registered marks? And if so, they will refuse your application. All right, so we're just going to pretend for purposes of this slide, they don't find any similar marks or other problems with your application and it gets approved. Now, to give you an idea of what is normal, it's actually over 83% of the applications that are filed online have at least one problem with them, sometimes many problems. So this is the exception that an application would go straight through to approval. But to keep things nice and simple on our slide and keep it moving, we're going to say your application is the exception. It goes straight through to approval. Notice one thing here. Approval is not the same thing as registration. You are not across the finish line yet. So what happens here is the USPTO says, you know what, we don't have any problem with this application. We feel good about it. But general public, do you have a problem with this application? And it's kind of a speak now or forever hold your peace type situation. So the general public has 30 days for somebody to step forward and say, no, 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 do not register that. I have that mark already, and do not let that go to registration. That's called an opposition. But if no one from the public opposes you, the mark registers. And usually an opposition is not filed. That is the exception, that an opposition would be filed, but it does happen from time to time. All right, so once you actually get that registration, what does it mean for you? What are the benefits? Well, there are several. I'm just going to hit on what I consider the top three. The first is that you get to use the circle R symbol. And you might look at that and think like, well, why do I care if I get to use the circle R symbol? This puts everybody else on notice that you have a federal registration. So before you actually get that registration, you can use TM or SM with your logo, with your mark, but you cannot use this circle R. So when someone sees that circle R, they know you have that registration. And if they were thinking about using a similar mark, then hopefully when they see that, they say, you know what, it's not worth the hassle. I don't want to fight anybody over this mark. I'll just come up with a different mark to use. So it has what we call a deterrent effect. All right, your second big benefit is that the mark is in the federal trademark database. So what does that mean? It means you have your registration and maybe 3 weeks, 3 months, 3 years from now, somebody else files an application for your mark or something really similar to it. Well, that application is going to go through the same process. And here, where the attorney at the USPTO is reviewing that application, they're going to search the Federal Register. And if this newcomer's mark is too close to yours, then guess what? Your mark is going to pop up in that search. And they were going to say to that newcomer, no, you cannot have this registration because someone else already has this mark. So that is good protection for you. And then we have our big benefit number 3. There is a legal presumption that you are the owner of this mark. So without getting super technical, that just means that if you ever did have a legal dispute about the mark, then basically you have the benefit of the doubt from the court. The other party that is trying to say they are the rightful owner, they have an uphill battle legally. All of the evidentiary burden is on them. So that is a good position to be in if you ever end up in a legal dispute. You do not want the burden to be on you. All right, so we are done with that flowchart slide, and I promise everything from here is easier. So a federal trademark registration means you have the exclusive right to use your mark in connection with your identified goods or services throughout the US. Just to break that down, the throughout the US means if you file with the USPTO, you file this one application, you get coverage from coast to coast. You do not have to go around individually to each state and apply for a trademark registration in each of those states, right? The exclusive right, people love this part because it means you get to exclude other people from using your mark or something that is too close to it. And if you find out that someone else is using your mark, you can send them a cease and desist letter, which is just a nasty little note that says, hey, you don't have the right to use this. This is my mark, and you have to stop. Now, the part of this that tends to surprise people is in connection with your identified goods or services. So a lot of times people call me up, they think if they get a federal trademark registration, they can use that mark for anything under the sun, and they can prevent other people from using that mark for anything under the sun. So it does not work that way. When you file your application, you will have to explain how you use your mark, what you use it with. So remember, the trademark, the whole purpose of this is to indicate the source of certain goods or services. So you have to say, what are those goods or services that your mark is used with? So for me, it's legal services. For you, it might be clothing, it might be a mobile app, it might be fragrances, pretzels, whatever the case may be. But you will have to explain how you use that mark, what you use it with. And then that determines basically the boundaries, the scope of protection that you get. So hopefully this will make more sense as we go along. But you not only have to explain what you're using your mark with, you also have to put those goods or services into the correct class. So what do I mean by that? The USPTO has a system of 45 different classes of goods and services. So everything has a home in this system. I'll give you a couple of different examples. So my legal services are down here in class 45. If you have just normal clothing, shirts, pants, shoes, hats, that kind of thing, it's here in class 25. But if your clothing was like those gowns that you wear when you go to see the doctor, that would be over here in class 10 because that's where our medical goods belong. If your clothing was not even for people, if it's like doggy jackets, this is pet clothing, you're actually over here in class 18. So everything has a home in this system. You just have to figure out where it belongs. The other thing I want to highlight for you before we move on from this slide is that the total number of classes in which you identify goods or services is going to determine how much you have to pay the USPTO for your filing fees. And those are just the fees you pay for the privilege of having your application reviewed at all. So just a quick idea of how this works. You could easily have like 50 different kinds of clothing goods in class 25, hats, pants, shirts, socks, on and on and on, okay? But if all 50 of them are in class 25, then you just pay the one fee for the one class. But let's say you have class 25 clothing goods, but maybe you also sell jewelry down here in class 14. A lot of people do both of those things. Maybe you also have sunglasses, which are here in class 9, and maybe you sell purses, which are in class 18, and maybe you have a website where you sell all of those things. That's online retail store services down here in class 35. So now you're talking about an application with 5 classes, and that is going to cost 5 times as much to file as an application for just class 25 clothing goods. Okay, so a quick overview there, but you will hear me say classes and goods and services like a million times in this presentation. So now you know what I'm talking about. All right, So let's move on to our second topic. This is when to think about trademarks. And I just want to give you three key considerations. So first of all, you definitely want to think about trademarks before you finalize your packaging or start promoting your product or business. And why is that? Well, basically, we are concerned about whether you even have the right to use that mark at all. If somebody else is out there and they are using your mark and you started before you may not have the right to use your mark. And when they find out about you, whenever that happens, they may send you that cease and desist letter. And you do not want to be on the receiving end of that because at that point, you basically have two not great options. Okay. One is that you fight this out. If you hire an attorney to fight this out, that can cost you thousands of dollars, maybe tens of thousands of dollars, maybe more, depending on how much time and energy and money your opponent has to fight over this. It can also take several years to wind its way through the legal system, through the court system. So if you look at that option and say, wow, I do not have the time or the money to spend fighting over this, then your other option is to go through a forced rebranding, which nobody really wants to do. That means that if you already have your packaging out there, now you've got to go redo your packaging. And if you have been on all of these various social media platforms promoting your product or your business, well, now you got to get back out on those and say, you know what? We used to be called that. We're now called this. And people will ask you, well, how come you're not called that anymore? And do you really want to have to say, well, I didn't do my due diligence, I didn't do my homework, there was somebody else out there who already had the name or had the logo, and so we had to change it. It doesn't put you in the very best possible light. It doesn't inspire a lot of confidence, right? So you don't really want to be in that position. Um, I will tell you, lawyers basically do one of two things. Like either you are trying to avoid a problem before it happens, or you are trying to clean up a problem that has already happened. It is much easier and cheaper to avoid the problem before it happens. So that's what's happening in this slide. You're trying to figure out, can I even use this mark before you get yourself in trouble for using someone else's mark? All right. So the second thing that you want to think about is how far away from actual use you are. So there are multiple different filing bases. You will have to select one of them when you apply to register your mark. I am not going to talk about any of the ones that have to do with foreign filings, meaning you have filed an application in a different jurisdiction somewhere outside of the US. I am only going to talk today about two filing bases, and this is 1A and 1B. Um, I realized that the people who came up with these names did nothing to make them imaginative or interesting or memorable. But 1A just means I'm already using this mark in the real world marketplace. So if you go on my website, you're going to see my logo. If you pick up my product packaging, you're going to see the logo on it today, as of the date that I'm filing. 1B means I'm not there yet. I have the intent to use this mark in the real world marketplace, but I'm not there yet. Okay. So the takeaway there is that you don't have to wait until you are using your mark in the real world marketplace to be able to file your application. All right. Now, either way, if you go 1A, I'm already using it, or 1B, not quite yet, you will still have to, at some point in time, prove to the USPTO that you are using that mark in the real world marketplace before you can get your registration. So if you file 1A already using it, you do that with the application. You submit what's called a specimen of use, and that could be something like a screenshot of your website that shows the logo on it, or a photograph of your product packaging with the logo on it. So you do that in the application if it's 1A. If you file 1B and not using it yet, that buys you a little bit of extra time, about 6 months extra time, for you to show that you are using your mark in the real world. So if you think about from the date that you file your application all of these different things that happen in the review process. And let's imagine things go as well as they possibly could. There are no issues identified with your application. It gets straight through to approval. Nobody files an opposition. All right, well then about 30 days after all of that part has ended, the USPTO will send you a document and they'll say, okay, we're ready to see that specimen now. We want proof that you're really using this mark. And you have 6 months to respond to that. So you're looking at about, best case scenario, 1 year from date of filing until you have to show you're really using that mark when you file 1B. Okay, so if you get to that point and you still can't show that you're using the mark, maybe you are having problems raising enough capital. Maybe you're having some kind of issue with your manufacturer. They're backed up, as a lot of them are right now during COVID. So if you get to that point, then you can request an extension and you get another 6 months. You can do that up to 5 times. So maximum, you can drag this thing out maybe about 3.5 years in that neighborhood. So the thing about this though is when I say you're buying yourself an extra 6 months each time, I mean that quite literally. So if you file 1A, I'm already using, or 1B, I'm not using it yet. The filing fee is the same either way. But if you file 1B, you will always have to pay more because once you get to the point of showing your specimen, that's going to cost $100 when you file that document, and that's $100 per class. So if you had one of those 5-class applications, that's $500, okay? If you need that extension, it is $125 per class every time. So you can see if you drag this process out, it can end up costing quite a bit of money. So you might be thinking, well, why does anybody file a 1B anyway? Like, why wouldn't you just wait until you had whatever your mark is, on your website, on your product packaging, you can just go ahead and file 1A. Well, the reason for this most times is that our federal register is first come, first served. So a lot of times people are afraid. If I sit on this mark, I have this wonderful idea, I've been thinking about this for months or years, and I just want to make sure nobody else gets to use it. Well, they're afraid if they sit there and wait until they are actually using it in the real world, that somebody else might get to the application process before they do. So they're really just securing their place in line, and they're willing to pay a few $100s extra for that um, because that's still cheaper than trying to have a legal battle with somebody over a mark. So that is typically why people would go that route. All right, our third consideration is budget and priorities. So a lot of times for young entrepreneurs or startups, they're very budget driven. There is no shame in that. You might have 10 different trademarks that you would love to get protected, but your budget says you can protect one for today. Okay, so that's all right. It's not a catastrophe. You just triage. And you do that by thinking about, well, what is my most consumer facing mark? I will give you a quick example of how you would think through this. J.Crew has something like 55 active registrations on the Federal Register. Only about 25 of those are for the wording J.Crew or J.Crew plus something else, so like J.Crew Factory, J.Crew Baby. All the rest of those are for different things that do not include J.Crew. They have a lot of slogans. They have like wear your shade. If you were in the early days of J.Crew and you had a budget for one mark and one mark only, then you would think about, well, what do people think of when they want to get more of what I have? So for me, I have never in my life thought, I want a new shirt. I'm going to go to that wear your shade place. No, no, but I have thought like, I'm going to go to J. Crew. So if that is what people have in their minds when they're thinking about getting more of what you offer, that is your most important mark. And you go ahead and you get the registration for that first. So in the early days of J. Crew, you go ahead and register J. Crew. Then hopefully business is good. You sell enough t-shirts and you can come back and you can register Wear Your Shade and all of these other little slogans that you have, okay? But that's kind of how you think through it. Not all trademarks are equally important. So you start with the ones that are most important. All right, so now let's move on into our next topic, and this is searching. So if you spend any time talking to someone involved in branding or trademarks, you will see we're all a little bit obsessed with searches. And that's basically just because, we do want to make sure that you actually have the right to use your mark at all. We want to make sure no one else is out there who has priority over you, who was using that earlier. So when we're talking about searches, a lot of times people are like, well, what are we even looking for? We're looking for marks that are confusingly similar. Now, that is the legal term. And what that means in the real world is just would the average consumer who sees your mark used with your goods or services and the registrant's marks used with their goods or services be likely to think those goods or services came from the same source? If the answer to that question is yes, the marks are confusingly similar. And just a quick note here, the registrant is the person who holds that registration that might be blocking your path, that registration that might be a problem for you. So when you file an application, you are the applicant, and the person who holds the registration is the registrant. We put this in really concrete terms, okay? If I walk into Target and I see your logo on a bottle of ketchup and the registrant's logo on a bottle of mustard, am I going to think that mustard and ketchup is being sold by the same company? That's it. I can give you an example where we don't have any confusion as to same source. Sometimes it is easier to understand if you have a negative example. So we have Delta Airlines and we have Delta Faucets, and these companies coexist peacefully in the marketplace, even though they're using the same mark. They're both using Delta. So how does that work? Well, we don't have any likelihood of consumer confusion. People just are not walking into Home Depot and picking up a box with a Delta faucet in it and thinking like, wow, the airlines people have really branched out. Nobody is confused about that, and vice versa. They're just in such different parts of the marketplace, airline services and faucets, that we're not confused. We're not going to think that it's the same person that's doing both of those things. All right, so when we're trying to figure out if there is a likelihood of confusion, we are looking at two main concerns in this context, in the context of what is that person behind the desk at the USPTO thinking when they're looking at my application, okay? Our first main concern is how similar are the marks? And our second main concern is how closely related are the goods or services? Notice up here, I said how similar are the marks. I did not say identical. The marks do not have to be identical for this to be a problem for you. If they are identical, yeah, that can be a big issue. But there are other kinds of marks you want to look out for. So that includes marks that maybe are spelled a little bit differently. They just have one or two letters off, or maybe marks that have bigger differences in terms of appearance, but they sound the same. That is a really common problem. Or there are even marks that have bigger differences in terms of sound and appearance, but that have the same overall idea that they're putting into your head. They call this the overall commercial impression. The classic case for this is Blue Chapel versus Blue Nun. So chapel and nun do not sound alike. They do not look alike. But the USPTO basically said, you know what? We think that it's blue plus something religious. It's close enough. It's going to be confusing for people. All right. So just be aware the marks don't have to be identical. They just have to be similar. Similar thing down here, the goods or services just have to be closely related. They also do not have to be identical. If they are identical, yeah, that can be a big problem for you. But there are three other ways that goods or services can be closely related, three main ones that you want to look out for. So the first is if we know that the same company commonly sells both of these goods or provides both of these services. So we'll go back to our slide with the 45 different classes of goods and services. All right, so you remember I said a lot of times people who sell clothing also sell jewelry. So if you filed an application for class 25 clothing goods and someone else already had your mark registered for class 14 jewelry, you might get a refusal there. I have written up that exact refusal many, many times. One of the things I want you to notice about this is that the goods or services don't have to be in the same class for them to be related. We're talking about class 25 clothing and class 14 jewelry. So sometimes people think, if I'm filing an application for clothing in class 25, as long as there isn't a mark like mine in class 25, I'm good. No, 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 no. That is a myth, okay? You do have to look out for what else is in class 25, but you also have to look out for marks that are being used with goods or services that are related to yours. And they could be in different classes, just like jewelry and clothing. Okay. The second way that goods or services can be closely related is if we know that we can commonly get them in the same place. So, quick example here, if you go to get a haircut and you are at the register ready to pay, a lot of times there is this big rack of hair care products next to you that they are hoping you are going to buy on your way out the door. So, if you filed an application to register your mark for hair salon services and someone already had that mark registered for shampoo or conditioner, you might get a refusal there because we just know we can very commonly get both of those things in the same place. And then the third way that goods or services can be closely related is if we commonly use these things together. So the classic example here is peanut butter and jelly. If you file an application for your mark with peanut butter and someone already has that mark and they have registered it with jelly, you'll probably get a refusal there because we just use these things together so often. We think it's going to be very confusing for people if you have two different companies, but they have the same mark on their peanut butter and on their jelly. All right, so we know the search is important. We have a better idea now of what we're looking for. But how do we do that search? Well, the USPTO does have a tool on its website. It is free. It's called TEST. Unfortunately, this is not going to be a super helpful tool for most people. So I want to give you a heads up about that, first of all, and then to kind of explain why, what is happening there. So this was super common in my old job at the USPTO. I would issue a refusal, and then the applicant would call me up and say, I don't understand why I'm getting this refusal because I went on the USPTO website and I searched on tests and it said that there were no hits. So why am I getting this refusal now? And I fully sympathize that that is super frustrating, right? Um, the USPTO knows that this is a very common thing also because you'll see on tests there is this big warning after searching the USPTO database. Even if you think the results are okay, do not assume that your mark can be registered. So they know this is happening a lot. Well, why is it happening? Basically, TESS is just very robotic, okay? It does exactly what you tell it to, nothing more, nothing less. TESS is not like Google. If you type something into Google and it is a little bit off, then Google says, oh, did you mean? TESS is never going to ask you what you meant, okay? TESS is just not that friendly. TESS is going to do whatever you tell it to. So, as a quick example, if you typed in Disney with two E's and hit submit query, you would see no test records were found. If you type in Disney with two I's and hit submit query, again, you will see no test records were found. Now, does anybody think that you could file an application for Disney with two E's or Disney with two I's for, let's say, animated films and actually get that through to registration? No, no, there is no way on earth, okay? And you know that, and I know that. Tess does not know that. So if you wanted to actually see the kind of marks that you need to see, that maybe are spelled a little bit differently, that sound the same, you would have to search something like this, all right? And then when you do, you will pull up 771 active records, and that's going to include some Disney with the correct spelling. That's also going to include some things like this, which are not exactly Disney, but it's kind of in the ballpark. But if you look at this and you think, what on earth even is that? I fully sympathize. As far as I know, I think there's only one page on the USPTO website that even talks about this kind of search code. The only reason I'm comfortable with it is because when you work at the trademark office, they spend weeks training you on how to do this kind of search, and you have to do it many times every day. You get better at it over time. But the takeaway for you here is just that unless you have time to teach yourself how to do this kind of search, TESS is a tool of very limited utility because it might be telling you no TESS records were found, and there might be 771 things you really need to take a look at, right? So just be aware, if TESS says you're in the clear, you may not actually be. All right, so now we are going to move on to our very last topic before we open things up for questions, and that is distinctiveness. So remember, this is just how strong or weak a particular mark is. And like so many other things, distinctiveness is on a spectrum, all right? So we have at the top our very strongest possible marks. We have at the bottom our very weakest possible marks. And this is definitely our danger zone, descriptive and generic marks. We are going to get to those, but I want to start at the top with our strongest possible marks. These are fanciful marks. You might hear people call them coined terms. These are just made up words, okay? They do not exist other than you came up with them to identify the source of your goods or services. So things like Kodak, Buick, Exxon, Xerox, these are fanciful marks. And the reason they are so strong is because it's really unlikely that someone else is going to come up with the same weird wording that you did, and that they're going to be using that for goods or services that are related to yours. So these are the strongest possible marks. Right underneath that, we have arbitrary marks. These are marks that are real words, but they are used with goods or services they have nothing at all to do with. So the classic example here is Apple for computers, which I'm sure you are all very aware is a super, super strong mark. Well, Apple is a real word, but it has nothing at all to do with computers. So that's what makes it arbitrary. Then underneath arbitrary marks, we have suggestive marks. Now these hint at a positive attribute of the goods or services, but they do not come right out and tell you what that is. So an example here would be Greyhound buses. Greyhounds are really fast animals. So they are hoping you're going to make that mental leap and say, oh, these must be really fast buses. Now, if they came right out and said fast buses, we'd be down here in descriptive mark territory. But because they make you take this little leap, this imaginative leap, it's just suggestive. So these marks, fanciful, arbitrary, suggestive, as long as there are no other issues with your application, these can all be registered. And when we get down to descriptive and generic marks, it is a different story. A descriptive mark would be something like fast buses for buses or delicious cupcakes for cupcakes, all right? What is the problem with the descriptive mark? Well, it's not doing the heavy lifting of a trademark. Remember, what is a trademark supposed to do? It's a source identifier. It's supposed to help me identify the source of whatever it is I want more of. So delicious cupcakes, that's just telling me what the goods are. They're cupcakes and a feature of those cupcakes. They taste good. Well, I know I want cupcakes that taste good. But like, how do I get the ones that I want? If it was Dana's cupcakes, okay, that helps me to distinguish those cupcakes from somebody else's. But just delicious cupcakes, I don't know, that doesn't help me. The flip side of this, the other way to see it, is a question of fairness. All right, if I sell cupcakes and you sell cupcakes, we both need to have access to that word. If I get to say cupcakes and I exclude you, you have to say like baked goods with frosting on top. That's not fair. Same thing with wording like delicious. That's really just bragging wording. Well, we kind of feel like everybody should have access to bragging wording. Otherwise, I get exclusive use of delicious. The next person comes along and they take tasty. Someone else gets yummy. What are we left with? At some point, someone who's just trying to explain what their goods are is going to have to say like, oh, I sell not bad baked goods with frosting on top. It becomes absurd, okay? So we do not want to let any one person have the exclusive use of descriptive wording. All right, now what happens with descriptive marks we're going to come back to because these are in our danger zone, but I want to touch on generic real quick before we do that. All right, Generic marks, you are not even including descriptive stuff, not even like bragging wording at this point. You're just telling me exactly what it is that you do. So it's like pet store for pet stores. Well, same issues here. That doesn't help me to distinguish your pet store from somebody else's. It definitely isn't fair if you're the only person who gets to say pet store. So generic marks are actually never, ever, ever in a million years going to be registered. They are unregistrable 10 times out of 10. All right. Now, before we move on and talk a little bit more about descriptive marks, I want to just note for you, just emphasize everything we're talking about here on this slide, where you fall on this spectrum. It is all about the relationship between the mark on one hand and the goods and services on the other. It is all how these two things fit together. So remember I said Apple is a fantastically strong and arbitrary mark when it is used with computers. But if you use that same mark, Apple, for apples, guess what? You're down here in generic territory and you are never in a million years going to get that registered. So it totally depends on what you're using that mark with. Okay, so let's talk a little bit more about descriptive marks and some marks that are similar. These all fall into what I call areas of compromise, and you'll see why soon. So basically, and we have already talked about the merely descriptive delicious cupcakes for cupcakes. These are some similar situations where it's kind of a problem. What do we do with these? All right, well, we have merely geographically descriptive marks. Those are similar to your merely descriptive marks. You're just tacking on uh, sorry about the slide going back and forth. You're just tacking on a geographical term. So if we had Georgia Journal of Byzantine Studies, and let's say this is for an academic publication in the field of Byzantine studies, and the people who put that publication together are located in Georgia, well, this is still all descriptive wording, all right? So that is another basis for refusal. And then we also have merely a surname refusals. And this is similar because it has to do with fairness again. So if we had Fomini's caramels or caramels, there's a lot of people who have the surname Fomini, and they might want to use that mark with their own business. We think that that is pretty normal, pretty common, and we don't really want to let one person kind of lock up a surname. So if you think about a really common one like Smith, there are a lot of attorneys with the surname Smith, and they might want to call their business the Smith Law Firm. Well, it really wouldn't be too fair if we let one person named Smith have the Smith Law Firm and no other attorneys named Smith get to use them, right? So it's a question of fairness. Okay, so what do we do with marks like these? Well, I have been talking this whole time as though we had one register only, but there are actually two federal trademark registers, and I think you are ready for the truth. So I'm going to lay it on you. All right, we have the principal register and the supplemental register. By far, you prefer to be on the principal register if you possibly can, but if not, supplemental is a good fallback position. This is a consolation prize, but it is not all that. Okay, so I'm going to tell you two things they have in common, and then I'm going to tell you the main difference between them. So whether you are on principal or supplemental, you will still get to use that circle R symbol. And remember, that just tells people to back off. I have a federal registration, so come up with a different mark, and hopefully they do and they leave you alone. Whether you are on principal or supplemental, you are still going to appear in that federal trademark database of registrations. So when someone else files an application that is for your mark or something really similar to it, that attorney at the USPTO who's reviewing that application is going to do a search. They're going to pull up your registration and they're going to say, I'm sorry, newcomer, you cannot have this registration. Someone else got here first. All right, so those are two really good benefits, whether you're on principal or supplemental. The main big difference between these two is that your zone of protection on the principal register is just much, much bigger than if you're on the supplemental register. So let's say that someone applies for a mark that is spelled exactly the same as yours. Well, whether you are on the supplemental register or the principal register, that mark is not going to be allowed to register as long as it's used with goods or services that are related to yours, okay? In every case, that is going to be kicked back. That attorney at the USPTO is going to say, no, newcomer applicant, you cannot have this registration. Someone else already does. Okay. So you're protected for that kind of mark. When you move a little bit further out, and now you're talking about a mark that is spelled a little bit differently, but that sounds the same, and it's for related goods or services, well, 10 times out of 10, that is not going to be allowed if your mark is on the principal register. That attorney is going to refuse that new application, all right? And so that gives you a bigger distance between your mark and who else can coexist on that register with you, all right? But if you are on the supplemental register and if your mark is a highly descriptive mark, like delicious cupcakes, then it may be that just having a creative different spelling for that might be enough for the USPTO to let it register, to let it coexist with your mark on the supplemental register. So just be aware, when people come along with new applications later, they can get a lot closer to your mark if it's on the supplemental register than they can if it is on the principal register. And then the last thing I want to say before we open things up for questions is that you can sometimes migrate from the supplemental register to the principal register. So if you think about one of the examples I gave earlier, it would seem to fall into this category. I mentioned my love for McDonald's French fries. Well, in the early days of McDonald's, I don't know how many of you have seen the movie The Founder, but it was founded by two brothers with the surname McDonald. So if they had filed an application in year one of that business to register their mark, it would have been a great candidate for a merely a surname refusal. But what has happened since then is that they have poured who even knows how much money into advertising, marketing, promotions around the world. It has become a famous mark. They have sold an incredible number of burgers and fries and shakes under that mark. And so what has happened is that now, if someone says McDonald's to you, you don't think, oh, that's probably a business owned by somebody named McDonald. You think immediately of that particular fast food restaurant. Okay. So it has now evolved into a source indicating mark. We call this acquired distinctiveness. That's the legal term for it. It takes at least 5 years, usually of exclusive and continuous use before you could try to claim your mark has acquired distinctiveness. If it's something highly descriptive like delicious cupcakes, that alone would not be enough to get over that hurdle. You would have to show like how much you had spent on your marketing and advertising and promotions. You would have to show, maybe survey evidence of consumers that indicates when they hear delicious cupcakes, they don't just think about cupcakes that taste nice. They think about your specific cupcakes, the source of those cupcakes. All right. So realize it can happen, but it's not easy and it takes some time. All right, so that was a lot of information I know that I just threw at you. We're going to open things up now for questions. And this is a time for general questions about trademarks, trademark law in general. If you have specific questions about your particular situation, your specific circumstances, I'm happy to talk to you about those. But those conversations have to be one-on-one. You can contact me in either one of these ways. And that's really just because I have to protect your confidentiality at that point, and I wouldn't be doing a great job of that if I discussed your issue in front of everyone else in a webinar. So happy to talk about that by those means, but now is a great time for general questions.
And what I would invite everyone to do is go ahead and take this opportunity to go ahead and put your questions in the chat. We have about um, 15 minutes to entertain Q&A. We probably need to wrap up right at 3:20. So go ahead. I already have a couple questions in here, so I just wanted to go ahead and let you guys know. Go ahead and start typing your questions. But it's so funny that you ended with that example because right before everyone came on, we were just talking about Zoom, which is how all the technology problems started. We were talking about Zoom, and Attorney Dickson mentioned right before everyone came on how a year ago she hadn't even she wasn't even aware of Zoom.
Yeah.
And while Zoom is a very generic term, we were just kind of just chatting about how now Zoom launched into becoming a verb in of itself. When people think about um, video conferencing, Zoom is the do you want to Zoom? Just like Google. So it'll be very interesting to see in 5 years if Zoom will acquire distinctiveness. Because I also know that the word Zoom is found in a lot of dental applications. You'll see a lot of dentist names. They use the word Zoom. So that'll be interesting where to no fault of their own, just as a result of COVID, how the word Zoom has just kind of transitioned and taken on a life of its own. That'll be interesting to see. Um,
It's funny because you can go the other direction too. Like you could come up with a word that does not exist for your goods or services, and then you are super successful. And so people use that word all the time to refer to just that category of goods or services. And then you actually lose protection because the mark becomes generic. So it's called genericide. You
wow.
can't get too successful is the
Wow.
takeaway.
So funny
Weird.
story, just kind of tagging off of what you mentioned, and it's interesting. So you talk about the word and then also the category. So for example, apple not being a fruit but being associated with computers. We had a scenario several years ago where a client of mine, well, my coworker's client, started a chocolate business, chocolates, and she named the business Bellagio.
Okay.
Obviously, we know that there's a famous hotel out in Vegas with the name Bellagio. Hotels and chocolates are two different things. Surprisingly enough, the hotel came after the small local chocolatier and issued them a cease and desist order, even though two different categories. They wanted her to stop, and she had a decision to make and realized that, of course, Bellagio, whose pockets are much deeper, she decided she didn't want to fight and ended up closing her business, not just changing her name, but she just kind of threw her hands up.
That's incredibly sad.
It is,
Yeah, yeah. I mean, so,
but
oh, go ahead.
oh no, I was going to say just so you never know,
Yeah.
you never know. One question, the initial question, um, what's the relationship between, because of course, when you register your business in Georgia, you're basically checking your name against the Georgia Secretary of State. So where's the relationship between Georgia Secretary of State versus the National Registry? What's that relationship?
Yeah. Okay. So, the Secretary of State, when you register your business name and when you check to see if anybody else is using that business name, then you're not playing fair. I just saw that comment. Yeah, you're correct. So when you register your business name, that really just gives you the right to conduct business in that state under that name. And it's useful for you in terms of being able to open your bank account or to get your federal tax number, that kind of stuff. But it is a separate thing from getting a trademark registration. Now, there is the Federal Trademark Register, which the USPTO handles, but each individual state also has its own state level trademark registration process. And generally, I do not do state level registrations, but sometimes people will go that route if they can't get the federal level protection, or it's also less expensive. But in terms of being like efficient and your total cost at the end of the day, it is much more efficient and does cost you less to get that one registration through the USPTO than to try to go around to each individual state to get a trademark registration through that state. So that said, one does not communicate with the other and one does not guarantee the other. So if you are able to get a registration with the Georgia Secretary of State for your business name, that is awesome. That's great. What they are not doing is calling the USPTO and saying, hey, Dana wants to use Dana Dickson Law for her business name. Is that okay? Do you have anything like that over at the Federal Register? Um, that conversation is never happening. So you might be able to get your business name registered in the state of Georgia, but you might go to apply at the USPTO to get that registered as a trademark, and they might refuse it. So one does not guarantee the other, and they just do not communicate with each other at all. They are different governmental agencies operating at different levels.
I also get a lot of questions. Business owners, aspiring starry-eyed business owners want to protect their brand. They want to create protections around what they're building. When would you suggest? What's your tipping point? When do you recommend that it's worth someone pursuing a trademark at a federal level?
Yeah. So basically, once you get to the point that you are afraid that someone else might siphon off your customers, because that's the whole thing that it's protecting, really. It protects both sides also. Understand that this is a unique thing about trademark law. So you get that registration, and your trademark rights are protecting you as the person who came up with this wonderful business, or this wonderful product, and you have really high quality of whatever it is that distinguishes you from the competition. It protects all of that goodwill that you have built up and are continuing to build up with the consumer, right? So that people don't get to steal your clients away from you. But it also protects the consumer who is just overwhelmed with choice, and who wants an efficient way to find more of what it is they already know, like, and trust, right? So basically, whenever you get to the point that you think you have the budget for this and that there's a chance other people might try to siphon off your customers by using a mark that is confusingly similar to yours, they're trying to make that consumer think they're going to get from them what that consumer has come to trust in you. Does that make sense?
Yep, absolutely. Okay. Thank you. Thank you. Thank you. All right. So then one of the original questions was what if the mark is a combination of names? Does that matter if they have multiple names? Does it
In
still have to
terms
meet
of
the test that you were mentioning earlier?
Okay, so in terms of like registrability, um, many marks have a whole bunch of words in them. So it will depend in terms of like the kinds of refusals that I was laying out there on what exactly those words were. So like the mere descriptiveness refusal, if we were going to talk about that, um, if you have like five different words, but they're all descriptive, like the Georgia Journal of Byzantine Studies, that's a long one, right? But everything in there is descriptive, then it's still going to be refused. But if you had wording that was distinctive, maybe you came up with a weird word. An example I use a lot is thankful. It's like a weird Scottish word. But if you had like thankful chairs, okay, and you were using that with chairs, well, now only part of that mark is actually generic. It's just telling me exactly what the goods are. So that mark, assuming there are no other problems, it would be registered, but it would have a disclaimer of the word chairs. So the disclaimer is like a one sentence statement that goes into the record. It doesn't take anything out of the mark. The mark still registers in its entirety as thankful chairs. But you enter this statement that's basically like, I'm not trying to claim the exclusive use of chairs apart from the mark thankful chairs. So other people can use the word chairs. That's okay. They have to describe what they're selling, but they just can't use chairs with thankful, right? So that kind of gets at what the question was. It does make a difference if you have a string of words, what exactly those words are. It might be that, adding on a word that is distinctive is enough to make your mark capable of registering. You just have to put that disclaimer statement.
Disclaimer. Got it. Um, as I mentioned while we were chatting and waiting for everyone to come on, I was telling you about the artists that were going to be
Yeah.
joining us today, and a couple of them are on here. So one of the question was from one of the artists is relating to cartoons. This person creates and draws cartoons and wants to know what would he do about trademarking the characters.
Yeah. Okay. So That is a very, very good question. And that is probably something where I would, if you just email me, I can email you back about the characters. But that's a slightly nuanced thing.
Okay.
I'm happy to explain. It'll just take
Okay.
a little bit of time.
And what about with works of like spoken word and poetry? What's that? How does that process work?
So probably when you're talking about your spoken word and your poetry, you are going to be concerned with the the substance, the body of that work, the exact arrangement of those words, and that kind of protection that you will want is copyright for that. So you could not like trademark an entire poem, but you can get copyright protection for a poem.
Got it. Okay, so that's a different topic, completely different topic. Okay. All right. Let's see.
There is just real quick. The copyright website is good. It's a different part of the government. So USPTO handles patents and trademarks. There is a separate copyright office just for copyright filings, and they have a wonderful website. You can just kind of search around there, but they have guides for different kinds of things that you would protect, and they're called circulars, but that's all they are. So for like, they have one for software, they have them for all different kinds of things that you might try to get protected. So it is worth going on the copyright website. It's very, very user friendly and helpful.
Oh, good, good. You don't. I'm sure you don't get to say that very much about government agencies. So that's good that you can.
No comment.
It's useful. That's a positive thing. Awesome,
It's
awesome.
useful. It's useful. Yeah.
Let's see. If the trademark is the trademark about an image of the logo or the words? So this person wants to protect the words she is using. Is that well? I guess that goes back to what you were talking about relating to descriptiveness and being unique. So you discussed what could be trademarkable. The question is just where does it fit?
Yeah, so when we're talking about like designs and words, here's the breakdown on that. There are multiple different kinds of things that can act as marks, but the two most common marks you have are a standard character mark and a design mark or a special form mark. So the standard character mark is just when you want to protect wording. You get a registration for this, and you can use that wording in any font and any color and any stylization at all that you want. Okay, that's the broadest possible protection that you can get for wording. A different kind of mark is a special form mark, a design mark, and that is when you are claiming any kind of design element. So it could be just a design on its own with no wording at all, like the famous Nike swoosh, or it could be a design plus wording, as many logos have both of those elements. But that design mark is going to protect just that specific arrangement of those design elements, and also the wording that's in them if there is wording. So two different things. You would file two different applications if you had, wording that you wanted to protect as broadly as possible, and then a design that incorporates that wording that you wanted to protect the design. So they're two different things.
Okay. All right. Um, that appears last call. What? So I'm sure the answer to this is it depends, but you see the question, how much is the filing fee? So does that range? Is there a range on
Yeah.
filing fees?
So for the USPTO, in terms of the fees that you pay to them, it depends on which form you use. There are two forms, T's plus, T standard. If you file T's plus, it costs $225 per class. If you file T standard, it costs $275 per class. The one word of caution I would give you there is that a lot of times people look no further than those numbers to make their decision on whether they're going to file T plus or T standard. It looks like T plus is cheaper. It may not end up being cheaper for you. And the real quick reason for that is that you cannot lose T's standard status. There is no way on earth, but you can lose T's plus status. So if you file an application T's plus, you think you're saving $50 by going down that path, but there are 18 different ways that I know of you can lose that T's plus status. Like if you don't enter a translation statement, if there's foreign wording in the mark, a whole bunch of things like that. So if you lose T plus status, you have to pay a fee that is per class, and that ends up costing you $75 more than T standard. You just done T standard. Yeah, no,
Cheaper is not always less expensive is not always cheaper.
exactly. At the end of the day, yeah,
Yep.
yeah.
Okay. Attorney Dixon, you have been amazing. Thank you so much. The last thing I will ask is how do you suggest these folks get started if they do want to just sniff around and do some initial poking around to see if something's possible? Any suggestions for them? Where would you suggest that they start?
Just in terms of looking to see like if someone else has their mark.
Yes, yes.
Okay. Yeah. So you can look on tests. As I told you, it's kind of limited. You would always want to look through Google and just see if someone else has anything like what you have. Also, I search hashtags a lot to see if anybody is using it in social media. Another thing is like to look in dictionaries to see, this is more for like if the wording is descriptive. I also look like not just in standard dictionaries, but like slang kind of dictionaries just to see if there's some um, commonly understood meaning, but you know, that I don't know about. You also want to look to see like if there's any other potential problem, like the surname thing. You can look on, there's a couple different websites that have surnames you can search, and you can see like how many people in America have this particular surname, just to see if that is going to be a problem. So there's a whole bunch of little websites that you can look at, but definitely like the easiest place to begin is just to do a Google search, see if someone else has.
And just see what's out there.
Yeah, yeah.
Okay, yeah. Desiree mentioned, can you do it on your own or need a lawyer? I'm going to take a stab at this, and
Okay.
you take it from there. My suggestion is just because you can, that doesn't mean you should. Could you complete the application? Probably. You probably can understand the questions and fill it out. But the problem is, it would probably cost you a lot more to clean it up on the back end or to resolve the issues or resolve the problem than it would be to spend the money on the attorney up front. How close am I?
Yeah, I think you hit the nail on the head.
You
Yeah.
probably could, but it's probably once you have reached the point that yes, this is something I want to protect. You're starting with the end in mind. You realize that this is probably bigger than you and you're ready to take that leap, then it's probably worth the investment to get the attorney. Would you think?
Yes, yes. For all the reasons that you just said. Like you can fill out the application and kind of hope for the best, but it is not like going to the DMV. So I think I mentioned briefly in the presentation, but like over 83% of the applications that are filed online have at least one problem with them, right? And some of them have a whole bunch of problems with them, and it's not an intuitive kind of field of law. Um, so there are some things that are much easier than others, like copyright. I honestly, I do not file copyright 9 times out of 10 for my clients because I think they can navigate that process pretty easily. I have only filed where there's like an active dispute about who owns the copyright. So that is a process that is much more intuitive and more easily handled. But trademark law just is not like that at all. And so a simple thing that might seem like that's the right answer, that's the right thing to put in there, it can create a problem that is very difficult to walk back. Like even if you identify your goods in a way that makes sense to you, but isn't the way that the USPTO wants to see that, you may not even be able to walk that back and fix that, which is a really small, minor issue, right? But you might have to file your application all over again, which is the additional fee, but it's also that time lost. You know, you're trying to get your priority date, you're trying to get your foot in the door before someone else does. So yes, that's my long-winded way of saying I agree with you.
And what is the consultation fee? If one of these folks did decide that they wanted to move forward, is there like a standard 1 hour or 45-minute consultation that you would start with? And what does it cost to do that?
Yeah, so it's going to vary for you from attorney to attorney, like how much they charge, if they charge you for a consultation, if they do a flat fee, if they do hourly. But I can tell you what I do. So I do consultations for free. I don't do any charge for that. And that is by phone. I do everything online these days. So anyway, then I break the process down into two parts and I do a flat fee. So the first part of that is basically just trying to do that search, make sure there are no other people out there using that mark already, and also reviewing the application materials. Basically, you know, doing what I did before for years, just doing a pre-review review, see if there are any serious issues here. I charge $600 for that. If there are serious issues and I say, listen, I don't think that this can go through to registration, and I break it down, I rank it like 1 to 5. One, I don't see any serious problem. 5 is I don't think there's any chance you're ever going to get this registered. If it's a 5 and we don't think there's any point in going forward, then we don't, right? But then the second part of that is cleaning up the issues with the application, doing the actual filing. And that is also $600. And that includes a filing fee for the USPTO for one class of goods or services. And
Okay.
if you had other classes, we add on just the filing fee that they would charge, no additional charge from so I break it down into two phases because I think that's the fair thing to do. You will see people who do it both ways, who break it down into two or who just charge one overall fee for the whole thing. But to me, like if we see that there's no point in filing, it's not really fair to charge you for filing an application that has no chance of ever getting to registration. So that's
That's
how I do it.
awesome. That's awesome. You mentioned you had a hard break at 3:30. We are right at it. I want to
Yeah.
respect that. Thank you so much. Thank you, Panthers. Give her a virtual round of applause. We appreciate your time, Attorney Dickson. Thank you, thank you, thank you. Thank you to your dad for being a Panther and planting this seed in you. We appreciate you and hope that you'll consider coming back again. Desiree said you rock.
Thank you.
So thank you so much. I hope you enjoy the rest of your afternoon. If anyone is interested, just shoot me an email. We're going to go ahead and get this recording up on mine sometime next week. Give me till Tuesday or Wednesday to get that done. And I appreciate you. I hope you have a wonderful afternoon and a phenomenal weekend. Everyone stay safe and vote. Mask up and vote. That's my political campaign for the afternoon. Take care. Thank you so much.
Thank you. Thank you for having me. It was a
Okay.
pleasure.
Awesome. Have a great afternoon, everyone. Bye.